On August 18, 2026, Chief U.S. District Judge Reed O'Connor at the Northern District of Texas issued a 29-page ruling finding the ATF's frame or receiver rule unconstitutional on two independent grounds, the Second Amendment and the Due Process Clause of the Fifth Amendment, and entered a permanent injunction blocking its enforcement. That ruling dropped 48 hours ago, and most of the coverage is telling you half the story. Every channel is calling this the ghost gun rule being blocked. That is accurate, but it is incomplete, because the Supreme Court already ruled on this exact rule in 2025 and upheld it. A federal district court judge just found it unconstitutional anyway, on constitutional grounds SCOTUS deliberately left open. Understanding the difference between those two rulings is the difference between understanding what changed and what did not, and it is what determines whether this ruling protects you personally or not. Let me start with what the ATF's rule actually did, because the audience cannot understand what was blocked without understanding what the rule created in the first place. In April 2022, the Biden administration's ATF published a final rule amending the regulatory definitions of firearm, frame, and receiver under the Gun Control Act. Specifically, the rule changed 27 CFR sections 478.11 and 478.12 to encompass partially manufactured firearm frames and receivers, targeting 80% lowers, weapon parts kits, and similar items that had not previously been classified as firearms under federal law. Under the pre-2022 framework, an 80% lower receiver, a block of metal or polymer that is 80% machined to the shape of a lower receiver, but requires additional work before it can function as one, was not a firearm under federal law. It required no serial number. It required no FFL transfer. It required no background check. It was a piece of metal or polymer you could buy online, at a gun show, or from a manufacturer without any of the regulatory requirements that attach to a firearm. Under the 2022 rule, that same 80% lower, depending on how easily it could be completed into a functional receiver, potentially became a firearm subject to the full Gun Control Act regulatory framework. Serial number required, FFL transfer required, background check required. The rule used a multi-factor test to determine when a partially completed component crossed the line into regulated firearm status. And it was that multi-factor test, subjective, opaque, and entirely dependent on ATF interpretation, that became the center of the constitutional challenge. Judge O'Connor identified the core problem in a single sentence. The decision of when a hunk of metal or plastic may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver is left to the subjective determination of the ATF, and does not provide fair notice to the reader about when a component becomes subject to enforcement. A federal regulation that gives the enforcement agency unlimited subjective discretion to decide what is legal and what is a federal crime, without providing the citizen any clear standard, is not just bad policy. Under the Fifth Amendment's Due Process Clause, it is unconstitutionally vague. But before I take you through the ruling itself, I need to explain why this case is more legally complicated than every other coverage piece is suggesting. Because the Supreme Court's 2025 ruling changes the picture significantly. In 2025, the Supreme Court decided Bondi versus VanDerStok 7-2 and upheld the ATF's frame and receiver rule on statutory grounds. The court held that the rule was consistent with the Gun Control Act's definition of firearm. Congress had delegated authority to the ATF to define and regulate these items. The challengers who argued the rule exceeded ATF's statutory authority lost. The rule survived that challenge. That ruling did not end the litigation, it narrowed it. After Bondi versus VanDerStok, only two plaintiffs remained in the case, Defense Distributed and the Second Amendment Foundation. And they continued pursuing two claims that the Supreme Court statutory ruling had not touched: the Second Amendment claim and the Fifth Amendment vagueness claim. Those are the two claims Judge O'Connor just ruled on, and they are entirely separate legal questions from the statutory authority question SCOTUS decided. On the Second Amendment ground, the ATF's rule impermissibly infringed on the Second Amendment's protection of the right to personally manufacture and gunsmith firearms. The rule reached inert pieces of metal, objects that were not yet firearms, and imposed regulatory requirements on their possession and transfer. Judge O'Connor applied the Bruin historical tradition test. The rule lacked any founding-era historical analog for regulating the private manufacture of inert components before they became functional firearms. The final rule does not merely lack supporting analogs, O'Connor wrote. The historical record provided nothing the government could point to as a well-established tradition of this kind of regulation. On the Fifth Amendment vagueness ground, the rule's multi-factor test, asking when a component may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver, was so subjective and dependent on ATF's case-by-case determination that it failed to give ordinary citizens fair notice of when their conduct was legal and when it was a federal crime. That is, the void for vagueness doctrine under the Fifth Amendment. A criminal statute or regulation must give the person of ordinary intelligence a reasonable opportunity to know what is prohibited. The ATF's rule did not. O'Connor declared it unconstitutional on that ground independently, meaning even if the Second Amendment claim had failed, the vagueness holding would still invalidate the rule as applied to the plaintiffs. Let me state the legal relationship between these two rulings clearly, because this is where every other channel is getting confused. The Supreme Court in Bondi v. VanDerStok said, Congress authorized the ATF to regulate weapon parts kits and unfinished frames. The ATF was acting within its statutory authority. Judge O'Connor in Defense Distributed v. Blanche said, even assuming that statutory authority exists, exercising it in this specific way, through this specific rule, with this specific multi-factor vagueness standard, violates the Second Amendment and the Fifth Amendment. These are not contradictory holdings. They address different legal questions. The Supreme Court resolved whether the ATF had the power to issue the rule. O'Connor resolved whether the way the ATF used that power was constitutional. Both holdings can coexist, and that is exactly what is happening. Now let me tell you precisely who this ruling protects, because the injunction scope is the most important compliance information in this entire video. The court declared 27 CFR section 478.11 and section 478.12c unconstitutional and entered a permanent injunction. That injunction blocks enforcement of the rule against three categories of people and entities: Defense Distributed as a company, the Second Amendment Foundation as an organization, and all current and future SAF members, but only as to the specific Defense Distributed products named in the order. Those products are Defense Distributed's M1911 80% frames, G80 build kit, unfinished receiver, and grip module. If you are an SAF member and you own or want to purchase one of those specific Defense Distributed products, the permanent injunction protects you from ATF enforcement of the frame and receiver rule as to those items. The regulation, as written, cannot legally be applied to you for those products while this injunction stands. Now let me tell you precisely who this ruling does not automatically protect, because this is the compliance gap that matters most. If you are not an SAF member, this injunction does not cover you. If you own 80% lowers or weapon parts kits from manufacturers other than Defense Distributed, brands not named in the injunction, this ruling does not automatically extend to those products. If you live outside the Northern District of Texas, this ruling is not binding precedent in your jurisdiction. It is persuasive authority, but courts in other circuits are not required to follow it. The ATF's frame and receiver rule remains technically in force for gun owners and manufacturers not covered by this injunction. The rule was not facially struck down as unconstitutional for everyone. It was declared unconstitutional as applied to the named plaintiffs as to the named products. That distinction is exactly how federal courts operate when they issue as-applied rulings rather than facial rulings. SAF Executive Director Adam Kraut said it plainly. This rule was such a mess that it not only violated the Second Amendment, but was so terribly drafted that it managed to be ruled unconstitutionally vague. SAF founder Alan Gottlieb added, "It was obvious from the outset that the Biden ATF's definition of a firearm was intentionally vague and provided no clear guidance to the average law-abiding American as to what was actually legal." On the other side of this ruling, Everytown Law's Executive Director Eric Tershwell said, "There is no Second Amendment right to buy or sell an untraceable ghost gun kit without a background check. This decision is egregiously wrong, and we expect the Justice Department to promptly appeal." That appeal is coming. When the DOJ files its notice of appeal, expected within 30 days, the case moves to the Fifth Circuit. The Fifth Circuit is the same court that struck down the ATF's engaged in the business rule, the same court that has issued the most aggressive Second Amendment rulings of any circuit in the country, and the same court where the NFA suppressor lawsuit and multiple other major Second Amendment challenges are currently pending. If the Fifth Circuit affirms O'Connor's ruling, it becomes binding law across Louisiana, Mississippi, and Texas, and creates the kind of circuit precedent that accelerates Supreme Court review. Watch also for whether the Fifth Circuit issues a stay of the permanent injunction pending appeal. If a stay is granted, the rule would be reimposed on SAF members and defense distributed while the appeal proceeds, temporarily reversing the protection the August 18th ruling created. If the stay is denied, the injunction remains in effect throughout the appellate process. Let me close with what gun owners need to know right now, stated precisely. If you are an SAF member and own or intend to purchase the specific defense-distributed products named in the injunction, M191 180% frames, G80 build kit, unfinished receiver, or grip module, the permanent injunction entered August 18, 2026, protects you from enforcement of the ATF's frame and receiver rule as to those items. That protection is real, it is entered by a federal judge, and it stands unless the Fifth Circuit issues a stay. If you own 80% lowers or weapon parts kits from other manufacturers, or if you are not an SAF member, the ATF's rule remains technically enforceable against you. Do not treat this ruling as a blanket green light for all 80% lower transactions nationwide. Consult a licensed attorney in your jurisdiction before making any decisions based on this ruling about your specific products and your specific situation. The rule that the Biden administration used to regulate pieces of metal that were not yet firearms, the rule that created criminal exposure for people who could not tell from reading it whether their conduct was legal, has now been found unconstitutional by a federal judge on both Second Amendment and due process grounds. The Fifth Circuit will decide whether that ruling stands, and whenever this case reaches the Supreme Court, it will be the constitutional question Bondi versus VanDerStok deliberately declined to answer. That question is, does the Second Amendment protect the right to manufacture a firearm for personal use? And if so, how far can the government reach into that process before it crosses a constitutional line? August 18, 2026. That question now has a federal court answer. The next answer comes from the Fifth Circuit.